Hello and welcome. I'm Tiffany Baldwin, and an employment attorney here at Husch Blackwell in the Healthcare, Life Sciences, and Education Business Unit. Before we begin, I'd like to cover a few housekeeping items if you didn't see those in the slides before. At the bottom of your audience console, there are multiple application icons for your use during today. If you have any questions during the webcast, please submit them via the question box, and I will try to answer them during the webcast today, or if we need to go a little bit deeper, I will answer them later via email. A PDF of this presentation should be available in the program folder, and this program has been approved for HRCI, SHRM, and legal education hours. And to report your hours, there is a CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. In fact, the healthcare one about nurses and allied healthcare workers was a suggestion from some people that had joined me in the physician immigration one in February. And that's about all for housekeeping items. Let's kind of get the ball rolling. As a daughter of an immigrant, it's no surprise that I ended up practicing immigration law, but it was really my first case as a law clerk dealing with a physician that led to 25 years, focusing not only on employment immigration, but on the niche area of healthcare immigration. I spent my career working with hospitals and health systems and staffing and practice management companies throughout the United States on the immigration process for healthcare workers. And again, as I mentioned, the first webinar this year on this topic focused on foreign physicians. And today I will focus on options for nurses, medical technologists, and other allied healthcare professionals. So I know that you're all trying to find different ways to deal with healthcare worker shortages, whether it's a growing use of staffing agencies or these kind of high schools to hospital grow your own programs. And I think that recruiting foreign workers could be another tool in your bag because it's a pretty good one. But I understand that dealing with immigration issues often scare organizations. There's various pathways and they can seem very daunting. And so my aim today is to demystify the process and give you kind of a basic understanding of your options so that you can create a sort of bespoke strategy and recruitment plan that fits your organization's needs and your kind of next 5 years, so to speak. And this knowledge should, I find that recruiters that have knowledge of kind of basic knowledge of immigration have a bit of a competitive advantage in recruiting. So I'm going to start off with a very, very basic primer on immigration law. We'll talk a little bit about the visa screen requirement, and then we'll talk about the non-immigrant options and the immigrant options for healthcare workers. We'll end with some final thoughts and get to your questions and see what may be helpful for future webinars. So your little 101. In short, to understand how foreign nationals come to the United States, you got to learn about visas. And in the United States, visas are broken into two main categories. There are non-immigrant visas and immigrant visas. And non-immigrant visas are, you know, the alphabet soup of visas. So they are temporary, so they're renewable, but they are limited in time, and they're geared towards a specific purpose. Think F1s for college students, B2s for tourists, Ps for athletes, again, alphabet soup. And certain of those non-immigrant classifications are for employment. The primary employment one that you've probably heard of for degreed professionals is the H-1B. On the other side of the coin, we have immigrant visas, permanent resident visas, often called green cards. Someone with a green card can stay and work permanently in the United States and can eventually apply for citizenship. The primary ways of getting a green card is either through employment or a family relationship, although there are some other ways. So I mentioned the visa screen is because for all employment-based non-immigrant and immigrant petitions for these 9 healthcare occupations in the slide, they require a visa screen. And that's true even if these individuals are educated and trained in the United States. Essentially, the visa screen is a credentials assessment. So they look at education, licensure, English proficiency, and then there's either the NCLEX or an international qualifying exam for nurses. It is administered by the Commission on Graduates for foreign nursing schools, even for those occupations that are not nurses. And, again, that's going to be required to file any of these. So I do want to mention that. There are some occupations in that healthcare realm that don't require the visa screen. And those are those technologists that don't handle blood or bodily fluids. And those are listed there. Also, for a small segment of nurses going to work in a small number of states, there is kind of a streamlined, modified visa screen called the certified statement. So I mentioned it because there are some people on this call from Florida, Georgia, Illinois, Michigan, and New York, and it's kind of good information to have. So the H-1B, as I mentioned before, is a work visa for specialty occupations. I include in my discussion of H-1B kind of the H-1B equivalent for Australian citizens, called it the E3, and the H-1B1 is for those from Chile and Singapore. And what they mean by specialty occupation is that the position must require a bachelor's degree or higher in a specific field or kind of group of related fields as the minimum requirement for the position. And immigration is not going to take your word for it. So they are going to look to see whether the degree is common in the industry, among parallel positions in similar organizations, and that's kind of the key. And then, or if the employer normally requires it, or the job duties are kind of specialized and complex, that would kind of lean towards having a bachelor's degree. So when we're looking at those that are common to the industry, we're looking at those that, well, again, advanced practice nurses, we're talking about master's degrees, or we're looking at those that just kind of across the board require a bachelor's degree. And so I listed kind of the common ones that we would see in the healthcare environment. But what about registered nurses? This slide would not appear in presentations 10, 15 years ago, 20 years ago. But we are, because typically registered nurses have not been eligible for H-1B as a kind of a general proposition. And that is because there are different ways to become a registered nurse, as you all know. So bachelor's degree, but also the associate's degree, also the diploma. And so immigration has not considered a bachelor's degree to be the normal requirement. But we are seeing kind of an evolution of that. And we're seeing more H-1Bs being approved in certain circumstances for registered nurses. Part of the reason is that the Immigration Service relies on the Department of Labor, in particular its Occupation Outlook Handbook, OOH, to see what kind of the general sense of a job is and what the normal requirements are listed. And the OOH now has as the typical education requirement for an RN as a bachelor's degree. They still mention the associate's degree, they still mention the diploma, but they talk about how employers, and particularly in hospitals that require a bachelor's degree, and other Department of Labor, especially the BLS documents, they also talk about the bachelor's degree being the typical entry-level education for an RN. So we are seeing that change with immigration, also because we are also seeing that, I think 41% of hospitals and healthcare facilities are requiring a bachelor's degree now, and about 82% of employers are strongly preferring the bachelor's degree. So we're seeing that evolution such that this is becoming more of an option for employers. Those changes are not really the end of the game. Typically, immigration would want to see a healthcare hospital's, let's say, hiring history. The last 5 years for this role, they've hired, those that have a bachelor's degree to show that their hiring history comports to having a bachelor's degree. Some specialized RNs, ICU, emergency room, perioperative, et cetera. Those are kind of specialized and complex, not quite the advanced practice, but those also you can show because of the job duties being, again, complex. Also, if you're one of the 600 magnet recognized hospitals, that too, because of the requirement or the, I guess, goal of having 80% of registered nurses have a bachelor's degree for those hospitals. So we're kind of seeing that evolution. So once you've determined, that yes, this occupation, we can probably file an H-1B for, can we actually file the petition? So one of that has to do with the credentialing, right? So in addition to the visa screen, nurses have to have the NCLEX. And also if a state license is required for that occupation, they have to have the license in order to file. And that's where sometimes we get into issues with Social Security numbers because the state won't issue the license without the Social Security number, but you can get the Social Security number without the visa. So there's a little chicken and an egg thing that goes in that have to be worked through. But again, it's overcomable. But the big thing, whether it's healthcare or not, is that H-1Bs are numerically limited. There's only 85,000 new H-1Bs for each fiscal year, and 20,000 of those are for advanced degree applicants. And so we have a supply and demand issue for a lot of hospitals and health systems that may not be an issue because there are certain employers who are exempt facilities. And that would be institutions of higher learning. Also, not-for-profits affiliated with those institutions of higher learning. And that can include those that are affiliated by way of having a clinical affiliation agreement, let's say. Their radiology techs rotate through each semester, something like that. Also, especially this is good for like the staffing agencies and the practice management, even if it's a for-profit company, if the healthcare worker is going to be working at a health facility that would be cap exempt if they were the direct employer, so that's a way to get around the being cap subject. If you happen to be a hospital that is cap subject or an employer who's cap subject and you can't get around that, there is an annual kind of lottery. I jokingly refer to it as like the Hunger Games, but it is a lottery that is held in March to determine who can get the golden ticket. Now I'm mixing my references to be able to file the H-1B. Other issues with the H-1B are that employers have to pay the prevailing wage. So in order to protect the wages and working conditions of U.S. workers, which is kind of the goal, is that they have to pay at least the wage that the Department of Labor says is for that position based on those requirements, the geographic area. And there's 4 different levels, entry all the way up to experience. And those come out every July. So there's a way to kind of look what they are to see kind of where you are in the range. Usually that's not typically a problem. And then there's a time limit. So H-1Bs, they're renewable up to an extent of 6 years. So usually during that time, employers try to start that pathway to the green card. There are some exceptions to that 6-year, depending on where that individual is in the green card pipeline. And so that's why starting that green card process is important, because even if it's not finished within that 6 years, there's opportunities to kind of go the 7th, 8th, 9th year if needed. Hopefully not. Okay. So there are not a lot of alternatives to the H-1B, but the TN is one of them. The TN was started through kind of NAFTA, which is called USMCA right now, and it's only for Canadian and Mexican citizens. But it is a great resource. Unlike the H-1B, which can be kind of flexible with regard to the occupations and it's kind of fluid, there is an exact list of occupations that are for TN. Fortunately, there are a lot of healthcare occupations on that, including nurses, including med techs. And so if you happen to find that nice match between a registered nurse who happens to be Canadian, it's great. But like H-1B, again, the visa screen is required for nurses. It's going to be that NCLEX, or that international credentialing state license. The TNs don't have that 6-year limit. They're usually awarded for 3 years at a time, and that's renewable. And they tend to be a little bit faster. You can apply while they're in the United States and go through the USCIS, but there is this nice option for Canadians to be able to apply at the border or at the pre-flight inspection at the airport, because Canadians don't need actual visa stamps, which can be a time saver. And Mexican citizens can apply at the U.S. consulate in Mexico. So sometimes it can be a really quick turnaround if the credentialing is all there. And then for those foreign nationals who are doing their studies here in the United States, there is the optional practical training, which is a 1-year work authorization at the end of their studies once they get their degree. And that's for even associate's degree, BSN, master's. You don't have to sponsor them. They come, they have a little card, you I-9 them, they're good to go. You don't have to worry about visa screen. You don't have to worry about prevailing wage. Obviously, state license required, and state license is required. Even though you would, and then there's 2 additional years for STEM degrees, which you would think would include all of these healthcare occupations, but they don't. There's 13 pages of majors that are eligible for the 2 years of STEM, and there are very, very few that fall within healthcare. But medical technology, clinical laboratory science, that does fall under there. So there's that 2 additional years, which is nice. So that's, again, another option if they're, if they're getting their studies here. There might be some other, there may be some other visa categories, non-immigrant visa categories, but it would be very case specific, like, really remarkable physical therapists, or there might, that we're not really going to cover because we don't really have enough time. So those are kind of the big big ways to employ them on a kind of shorter term basis or a faster turnaround time, relatively speaking. Now we're going to go to the other side of the coin, which is the path to the green card or the immigrant visa options. This cartoon here, the waiting so long, I took that from a PowerPoint that I did on this topic in 2008. It really has not changed too much as far as wait times and So this is very much a long-term strategy, but I don't see healthcare shortages getting less anytime soon. So the long-term strategy is still a really good strategy. There are two pathways to the green card. The primary one really for all employment-based cases would be the perm labor certification. And then there is a kind of a special way for nurses and physical therapists. Again, it is a long-term strategy. And if we have time, I will show you some of the wait times or processing times to hammer that home. First, the primary way, the perm labor certification. What the labor certification is, again, in the hope to help the wages and working conditions of U.S. workers and make sure that we are hiring from U.S. Hiring U.S. workers before others. It is a test of the labor market, the local labor market, to determine that there are no minimally qualified and interested U.S. workers for that position. So it is really a labor market test at the time that you're filing. The first step in kind of that whole process is to request a formal prevailing wage determination. So again, it is based on the requirements, the job duties, and the geographic area, and they're taking about 6 months to get those back right now. That changes, but that's really pretty much how it is. Once you have that, or even before that you have that, you can do the labor market test or the recruitment part of it. This is where the Department of Labor, and this process is through the Department of Labor, is still stuck in the 20th century. So there's a 30-day job bank posting, not a problem. There is a posting at the employer, great. Professional jobs, there's 3 different types of recruitment: employer website, career service, college career service. You pick 3 from a choice of 10. There's also 2 Sunday print newspaper ads still in 2024. So I just think it's funny. But that's still the requirement. So all that is done, all that recruitment or the labor market test is done. You determine that there aren't any minimally qualified interested U.S. workers or enough of them. And then you wait 30 days and then you file with the Department of Labor this labor certification, which are taking 13 months right now, which is crazy. That time may decrease because there is a new system that was put into place last June that they're finally now getting to. So we'll see. Watch this space. Once the Department of Labor says, okay, yes, you have rightfully determined that there aren't any minimally qualified U.S. workers and you're good to go, then there's a filing with Immigration Service. It's called an I-140, and that's where the employer needs to show that they have the ability to pay this person's wage, and that the foreign national was qualified for that position. So they had the license, they had the visa screen, all that, when the perm was filed. There's premium processing for that. There's regular processing for that. So that can take a varied amount of time. And then there's kind of the waiting game. There are a limited number of green cards each fiscal year, kind of like the H-1B, and they are broken down. There's a limited number of employment-based green cards, and within the employment-based green cards, they are based on the tiers. So there are 5 employment-based preferences. For perm, we're looking at the second and the third preference, and they are there's kind of a queue. There's not enough visas to go around. Even for those, I know a lot of people have heard, oh, the wait time is really long for those that are born in India or China, and that is true. It's super long. But even for those people called rest of the world, there's currently a wait time. Sometimes there isn't, but there is now. So if they're in the United States, let's say they're in the United States on a H-1B or on a TN, and they are able to get their green card, they're eligible at this time, they can file to adjust their status from the non-immigrant side to the immigrant side in the United States. So they don't have to go outside the United States for that. But if there is a visa available and that person is outside the United States, then there's a process to get that green card by going to an interview at a U.S. consulate in their country. So there's kind of two ways depending on where they are located at the time that they are eligible. So right now, based on all the current processing times, at best, and we're talking about those that were rest of the world folks, you're looking at 24 months from the date that the perm is filed until maybe they would be work authorized, either through getting the green card or having an interim work authorization. So again, long-term planning, and it's even longer for those that are born in India and China. And at certain times, there's other countries that have a longer wait time than the rest of the world. Sometimes Philippines is a little bit longer. Sometimes Mexico is a little bit longer. So Schedule A for nurses and physical therapists. And that's a wide range of professional nurses. So not just RNs, which is great. This is no perm. This is very, very good. I wish there were more occupations in the Schedule A. Basically, the Department of Labor has determined that there are some occupations that have just so historically had shortages that they don't have to go through that labor market test. Again, there's a lot more occupations that can go on there, but they haven't updated it in a while. So we are left with nurses and physical therapists. So, you get what you get and don't throw a fit. That's what I tell my kids. And the advantages, again, no labor certification. So there's 13 months of time that you kind of save, and the cost. And the cost. Obviously, if you don't have the perm, you don't have to have the newspaper ads and all that. So it is a streamlined process that should be used whenever you can use when they fall on that. In addition, at certain periods of time in the past, 30 years, there have been kind of set-asides for Schedule A workers so that there isn't a queue for them at all, and which is great. And right now there is pending legislation, it's still in committee, that would have a 25,000 visa set aside for nurses, which would be great, but it's an election year. It's not likely to get anywhere anytime soon, but it's on the horizon and we monitor it. And if it looks like it's going to be a done deal, then we'll be telling you about that. Again, the requirements are similar to any of those other filings in that they have to have the licensure, the certificate, and for nurses, the NCLEX. So again, that pathway, we've dropped the labor certification. There's still the prevailing wage requirement. Again, we're still protecting the wages of U.S. workers. And there is a posting requirement, but it's not really a labor market test. It's really just, a 10-day posting. Maybe if you have a weekly newsletter or something like that, or an intranet, then it goes on there. If there's a union, obviously you need to notify the bargaining representative. But again, it's a shortened timeline. There's still that 30-day waiting period, and then you go straight to the I-140. So skip the perm, and then you have the green card. There was a question, and I'm going to answer really quick because on here, in addition to Cassie's question about why is the wait time longer for India and China? That's because in addition to having limits on the number of visas by kind of category, there is a 7% per country limit on visas. So no more than 7% of the employment-based 2 visas can go to nationals of any one country, and it's not really even nationals, it's actually birth country. And so in certain, I will use the employment-based 2, which are our advanced degrees. There's a lot of physicians, IT workers, engineers, all that come from India and China. They are the 2 most populous countries, so that makes sense. And so they hit that 7%. So their wait time is sometimes a decade longer, if not more, depending on how things are shaking out with the numbers. So that's why they have a longer wait time. That would be lovely to get rid of those per country caps, but it is what it is. Okay, so we do have a lot of time. So, and this is kind of explains why the processing time and backlogs. So this kind of a visual. So the prevailing wage, again, that takes about 6 months. And the labor certification, you can see that as of June 30th, or July 1st, they were working on June 2023 cases. So yeah. And I'll explain a little bit. So these are the employment-based categories. Or I just was really going to focus on the second and the third categories. Here that I highlighted in blue, that's when they would have had to file their perm labor certification application or their Schedule A I-140 in order to be eligible for the green card next month. I put up August number. So again, you can see that there is, even for those that are, this is the rest of the world, there is a wait time. Obviously, there's even a bigger wait time for those that just have bachelor's degrees, or the job just requires bachelor's degrees. And then like the associate's degrees would fall under there. So, and you can see how much longer it is for China and especially for India. It's just kind of crazy. So that's why they are, it's a long-term strategy. Okay, this is not really well. So again, now I have a lot of time to get to the questions, but don't be afraid of recruiting foreign nationals. Again, a lot of them are clinically trained in the United States, and because of the visa screen, even if they weren't trained in the United States, they've gone through credentialing to kind of ensure that their English is good enough and that the training that they have had is kind of equivalent to what they would have in the United States. And I've seen this in my own practice, but also anecdotal speaking, that and other types of surveys, that foreign national workers tend to stay with their employer longer than domestic workers. In fact, just last month, I got a call from someone I did an H-1B for like a long time ago, did the green card, they got their citizenship. They are still at the same employer, but now instead of being the medical technologist, they are the lab director, and they are looking to recruit. So again, it's same hospital, and they've gone through the system. And when hospitals have a good retention program, then workers, domestic and foreign national, tend to stay. What works for one organization may not work for others. And so that's why knowing all the options, you can, again, create that customized what's going to work for you, and plan, do the timing, so you could do the budgeting and all that, so that you were able to meet your labor shortages in this way, or again, add that as another tool in your toolbox of recruiting. So I'm going to get to some of the questions, and please send them in because we do have a bit of time. I'm sorry if I spoke too fast. I was worried about running out of time. What are the advantages and disadvantages of hospitals utilizing an agency to recruit and employ international candidates on a long-term contract basis? There's kind of two different kind of staffing arrangements I've seen. One is really the recruitment and making sure that they're credentialed and they are able to get whatever exit visas. Some countries require kind of an exit processing from the country, Philippines being one of those. And it's nice when an agency that has done that a lot, they can do that quicker and easier than an individual hospital that may have a one-off situation. So recruiting and making sure that they're credentialed, there is value in that. And then there's some agencies that they are actually employing the individual and leasing them or using them to staff hospitals. And again, that works. Again, I don't know about the price difference between the direct employment and using a staffing agency when it's a long-term placement. That could probably vary. But again, the staffing agencies are very good when it comes to making sure that the individual is properly credentialed. They do kind of the initial review. They usually have someone from that country that can say, oh, well, that school is really good and that school's not so great, so I don't know about the training. So it's kind of insider knowledge of that particular country. And that, like I said, there's value in that. And there's a great deal of value when those countries have exit processing for their citizens, which is valid. I know, like for the Philippines, again, they had exit processing. That's because a lot of their citizens have been taken advantage of, not necessarily in the United States, although that might be the case, but in other countries where they go and they're mistreated. So it's making sure that their citizens, when they go abroad, are not going to go in a situation that is like indentured servitude, I suppose. So hopefully that gave you some information on that. And then I get, what are the approximate costs per employee to get the different visas? And are there ways for a hospital to protect their investment through employment contract? So the costs can vary, which I know is a very lawyer answer, right? For an H-1B, it will depend on the size of the employer, whether the employer is a not-for-profit or not, because there are different fees. Also, whether you're filing regular processing or just premium processing. So they just increased fees in April. So I would say if it's a small like a small nonprofit doing regular processing, you may be looking at $2,000 just in filing fees. Again, attorney's fees are going to also vary widely. And then if you have a large health system that's for profit, then they're doing premium processing, then you may be looking at $5,000 in filing fees. So again, it really depends on, those are a lot of variables. The TN, if they're filing at the border, or at the consulate, those fees are going to be relatively minimal. I think it's like $240 for the non-immigrant visa in Mexico. So then again, and you're looking at a time difference as well. There's no fees when you're hiring someone that's on an OPT. You hire them just like you hire anyone else. When we were talking about the green card, that is a longer process. It's multi-stepped. And so the fees are going to, for the labor certification, for the perm labor certification, there's not any filing fees, but you have the cost of the ad. And again, in addition to legal fees, with the I-140 stage, including the Schedule A, it could be around $1,500 if it's a smaller employer or less than that. Smaller employer and doing regular processing, but if you're a larger employer and doing premium processing, then you're looking at maybe $4,500 in filing fees. So it can vary. Those are fees that are employer borne for the most part. That means that the employer is responsible for them. And there are some cases, and some of those fees you can't pass on to the foreign national, but you think of it as an investment, just like your recruiting budget. If you got 10 workers through H-1B, but you didn't have to pay that money for recruiting, that's where you have to balance those costs. And then, are there ways for the hospital to protect their investment through an employment contract? Well, there are sometimes employers, and not just healthcare employer, all employers will do like a sponsorship agreement. If you stay a certain amount of time, then you don't have to repay. But again, some of those fees can't be repaid at all. So what you would get back if someone picked up and left after you had that investment. But as I said, a lot of the workers will go ahead and stay put, at least through the green card and a little bit beyond. But it's not uncommon for them to stay, they get citizenship and they establish their lives there. And then now we've seen through various court cases and regulations about non-competes. And so I will say that may not be an option for a lot of folks going forward, as it was previously to have non-competes. So so you got to think of it as an investment. And I think the ROI is probably a pretty good one, but it's still, when you speak with an attorney, again, we're open to calls, and we can, knowing how many you're going to recruit and which ways, then you can create a customized program and see what that budget would need to look like for that. Okay. I think that's all I see for questions. So just as a reminder, again, thank you for joining, and I will pick up on any questions that pop up as I'm giving you the end script. Again, thank you for joining us, and I hope the information was helpful. Again, some of those things we could probably go in more in depth, but I think this is a good broad understanding, and that gives you some food for thought, at least. You can get SHRM credit, you can get legal education credit, and HRCI credit. And there is a button at the bottom of your screen. I don't think it's on the bottom of my screen. The CEU icon at the bottom to log that in, and you'll get your certificate of attendance. That's nice. With the course numbers. So you have that for, if you need to pull that up in any way, and you have the recording. So feel free to share with colleagues that didn't have a chance to hop on the call. And again, we're here to answer any questions. Feel free to call on me. And there is a short survey. And, would love your feedback. Love your feedback. Okay. And then I just got another question, which is great. How can non-competes work with physicians on a visa? Yeah, so usually with physicians, and this is what I've seen, because again, a lot of my work has been with physicians, and with some of the visa filings that we have to do for physicians, particularly the J1 waiver, if you're familiar with that. A lot of those programs don't allow for non-competes. So that's part of the application process. So what a lot of organizations have done, or they already have, but they added in, they have the non-solicitation or the non-interference. They use that instead of the non-competes, and it somewhat accomplishes a similar goal, but at least on the physician side, it's more in line with the goals of that particular program, is to get physicians into underserved areas. So you want them to stay, even if it's not with the same employer. So that's why there's a no non-compete rule. But we found that the non-solicitation and the non-interference usually kind of serves as a good substitute for that. And now that we are seeing the no non-compete outside of the foreign national context, that would be a good thing for hospitals to really focus on as we see that climate changing. And that may be the same for, a small private practice with their advanced practice nurses or their physician assistant, to have a non-interference and a non-solicitation, so that if they were to go, those patients stay within the practice and they're not encouraged to leave. So those are options outside of the non-competes. That's a great question. Thank you, Tom. Okay, and then terminating, thanks. So there's different, for the H-1B, if an H-1B beneficiary employment is terminated, then there are employer, when they're filing the H-1B, they sign off on a provision that says that they will pay for the return trip home to the home country if the employment is terminated. And so for the H-1B, that comes into play. Oftentimes that is not requested or even required, because that individual might be going to another employer, and that other employer, when they file the H-1B change of employer petition, they take over that obligation for the return trip home. In addition, there are certain requirements, notification requirements to USCIS, that the H-1B is no longer in their employ. So there's that. And then one of the parts of the H-1B, before we can file an H-1B, there's a filing with the Department of Labor, but it's a short filing. It's an attestation showing that wages and working conditions and all that good stuff. So that document needs to be withdrawn. So there's no salary or wage obligations after the termination. For the TN, there's not a reporting requirement. And for OPT, it's free, it's open employment, if you will. So they would be treated like any other employee as far as employment termination. There's no reporting, there's no return trip home. So it's a bit easier, but H-1B, they do have those protections and those obligations. With the green card, once they have the green card, the employment, there's not a reporting requirement. So it's usually at that point that if there's a change, there's not going to be, anything done or needed to be done by them on the employer's half to report to immigration or the Department of Labor. There may be options when they're in that green card queue where they may be able to withdraw, or they would withdraw a pending application. That would make sense if they're no longer going to employ that individual. But beyond that, it's really the H-1B that has the obligations when it comes to terminating employment. I'm trying to think about any other things that maybe we missed on the presentation that would be helpful to you. I wish I would have had the bill number of the nurse. It's a nurse and physician bill, but I can go ahead and put that in. I can send that along with the email that will send your certificate, perhaps, and let you know that so that you can monitor that and you can see if your representative is a co-sponsor. It is has a lot of bipartisan support, which is unusual, but great. But again, I don't really see a lot of that going forward in this election year. But it would be a great help on both the nurse side and the physician side to have a set aside of unused visas. Every year they don't use up all the visas. They just because it's administratively difficult. And so to use those visas for nurses and physicians would be fantastic and would be very helpful for a lot of the hospitals and healthcare employers out there who have nurses that are in that backlog or physicians that are in that green card backlog. So I think that is it. Again, there's a survey, and this concludes our webinar. And thank you and have a wonderful afternoon, everyone. Bye-bye.